下午的研讨延续上午的主题，将会为您带来远距医疗在法政及政策面的课题，以及新世代医学教育的契机与挑战。The topics of the afternoon is going to be about legal and policy aspects of telemedicine and opportunities and challenges in next generation medical education. 在下午场的第一场演讲，我们邀请 Dr. Barry Solaiman, Assistant Professor at the College of Law, Hamad bin Khalifa University in Qatar 带来的演讲，并由阳明交通大学科技法律学院的陈鋕雄院长进行主持。主题是临床实务中远距医疗的法律和道德挑战。The topic of the current session is legal and ethical challenges for telemedicine in clinical practice. 让我们以热烈的掌声欢迎两位。
Good afternoon, distinguished guests, esteemed speakers, and participants. It's my great pleasure to moderate this panel. As we know that the popularization of telehealth during the pandemic have brought unprecedented challenging in terms of medical ethics and also legal issues. And those technology, including wearable devices, Internet of Things, and artificial intelligence, have already not just changed the relationship between doctor and patients, but also the role of hospital, and also bring some other new participants, third-party providers, AI companies, and also governments change of government role. So many countries already after COVID-19 actually already take actions in terms of law and policy to embrace this age, telemedicine age. For example, in Germany, they passed a law in 2020 and to a lot of budget to assist the hospital to upgrade their digital systems. And so there are many countries are doing their own approach. So it's my pleasure to welcome our today's speaker, Barry Solaiman. Professor Barry Solaiman earned his PhD in law from University of Cambridge, and currently he is Assistant Dean of Students at Hamad bin Khalifa University at Qatar. We probably know that some Middle East countries now actively promote digital health technology as they enhance their infrastructure of medical system. Professor Solaiman also now lead a project about developing guidelines for the use of AI in health research, and he is one governor in World Association for Medical Law, which will be leading international association in terms of law and medicine. He was editor-in-chief for Medicine and Law Journal, and he's now is a fellow at Harvard Medical School. Yeah, and also recently this year he published an important book, maybe the only one in this field, is a research handbook on health, AI, and law, which perhaps one of the only in this field. Yeah. So without further ado, let's welcome Professor Barry Solaiman.
Hello. Okay, you can hear me. Hello, everyone. Thank you for having me. I love this stand that I'm speaking to you from. I feel like I'm speaking to you from a garden, and I'm like behind the wall of the garden right now. So it's very beautiful. But thank you for having me to to hear me speak about some of the legal and ethical issues concerning telemedicine. So this is the book that, some of the insights I'm giving you come from my book. And this area of research I've been looking into for a few years now. It's a free book. The QR code is there. You don't have to pay anything for it. It's open access. So feel free to scan it and read it, because some of the issues I think are important that we raise with regard to AI, because it's becoming more integrated into telemedicine itself too, particularly with some of the new advances that are arising. So these are some of the, this is the plan I have. I'll discuss some of the applications, some of the interesting applications of telemedicine that have arisen just very briefly in a couple of minutes, before then just getting straight to the law to discuss some of the legal issues, particularly around licensing, the appropriateness of telemedicine, the legal standards that one needs to consider, and data protection requirements. So here's something that is a bit out of this world. So when we think about telemedicine, telehealth, we think about the doctor and the patient perhaps on a video call, and they're talking to each other via video. What some companies and countries are trying to do is to create a virtual hospital online, so through the metaverse. And so I wrote about this recently. This is sort of, we can think about telemedicine perhaps entering a new realm. And you know, for example, there are hospitals in Korea who've created these virtual clinics where you meet with a doctor that's represented as an avatar. I'm not sure how many people would actually enjoy doing that as a patient experience, but it's interesting to think about where this area is going. Here is another one, a metaverse hospital where you may virtually meet with the doctor. I don't think these applications are quite realistic for the long term. But it is an interesting space, because we see a lot of investment going into taking telemedicine, telehealth to the next sort of phase. And this is particularly through what's been termed meta-medicine. So the use of VR, AR, and MR. So virtual reality, augmented reality, and mixed reality. So for virtual reality, this is, you wear a VR headset. And the idea is, with the VR headset, you go and you into these virtual spaces and you meet with a doctor and you have this sort of consultation as you would in traditional telemedicine. Augmented reality is, if you think about Pokemon Go and you have the app on your phone and you're walking around and looking through the phone, there are applications also for this in healthcare in this big interconnected ecosystem. So here, for example, we have I know this is slightly different to a doctor and patient meeting through telemedicine. This is a doctor doing surgery, but they're wearing these goggles, and there's a connection of data going across different servers in different countries, which raises similar challenges. And things like robotic surgery, so surgery being conducted across borders by a doctor in one country controlling a robot in another country while they're doing the surgery. So this area is really becoming rich and interesting. And thanks to Apple releasing their Vision Pro headset, I think there's going to be a lot more investment in this space, because we see now there are apps being developed specifically for the Vision Pro by medical companies for the use in hospitals. And this is, for example, this shows a doctor accessing patient information using the VR goggles, being able to plan surgery. Here they're able to see before they operate the various bone structure that they need to look at before conducting the surgery. So, and here we have, this is also developed on the same, for the Apple platform by Cedars-Sinai Hospital in Los Angeles, creating a virtual therapist that you meet with in this virtual space to discuss your health and matters of mental health. So this is, I think, quite an exciting area. And when one looks at it in a lot of detail, it goes far beyond just the video consultation. There's a lot going on in this space. And this is why I mentioned that AI is relevant, because AI is a factor in a lot of these technologies. But now let's get to the law and think about what are the legal issues, because I think it doesn't matter how advanced this gets, we're still looking at a same core set of legal issues that the clinician needs to think about, that hospitals need to think about, and that regulators need to consider. And the first one is obviously, well, to me it was obvious anyway, is jurisdiction and licensing. So what happens if a patient is harmed and the doctor is located in a different country? Let's go with the basic example. Let's forget all of the fancy VR goggles. Let's just think about the situation where the doctor is meeting with a patient on video, through a video consultation. What are the rules in this area and how do they play out in different countries around the world? So one could think about a doctor meeting with the patient then and making an incorrect diagnosis or treatment recommendation for the patient that ultimately causes harm to them. So let's say the doctor fails to hear some important information when they're speaking to the patient, or there's a glitch in the system, the sound doesn't work quite right, or the image quality isn't good and they misdiagnose something. So if the doctor and the patient are located in the same country, legally it doesn't pose too many challenges. So let's say a patient in London connects with their doctor in the UK to have this video consultation. So from the perspective of licensing, it's easy for legal redress for the patient because the doctor is in their country, and the law operates in much the same way as it does a face-to-face consultation. There are a few other complicating factors when it's by video, but by and large, the law operates in a similar way. The complication arises, though, when the doctor is located in another country, and some countries have dealt with this in different ways. So, for example, in the UK permits doctors to, the UK accepts doctors who are licensed in another jurisdiction to give telemedicine to patients located in the UK. But that is not the case in all countries. So some jurisdictions require the doctor to be licensed in the country where the patient is located, whereas others will require that the doctor is licensed to practice in their own country and they can provide it abroad. The US is a really illustrative example of this because there's a difference between the different states as to what rule is allowed. So this is where then, if I just build on this, if the doctor is cross-border and in another part of the world, the law is not really settled on how to deal with this, and there are different ways that we can deal with this. One of them is through, and it gets more complicated because there are potentially three relationships here. There's the relationship between the patient in country A, doctor in country B. There is also the relationship between the telemedicine provider, the actual service provider, and the patient, and there's a relationship between the telemedicine provider and the doctor. And these you can have three different legal relationships here. So if something goes wrong, which avenue are you pursuing in the law to deal with these issues? So let's take the example then of the patient first, the patient and the telemedicine provider. What happens if there's something wrong in the system? They get advice from a doctor, patient is harmed. What can they have as a matter of redress from the telemedicine provider? And the answer is not very much, because when patients sign up to these, they usually sign up to these terms and conditions for using the service where they just press accept. And these are the end-of-user license agreements. And these end-of-user license agreements aren't really protective of the patient. They don't deal with medical matters like informed consent and the like. So it's not very helpful for patients to have redress through that route. When we're talking about the relationship between the telemedicine provider and the hospital, well, things become a bit more distinct then because there's usually a contract in some countries. So in the US, there will be a contract. Some service providers, telemedicine service providers have a contract with the hospital, and through that contract, if something goes wrong, the hospital is accepted, they will be liable, and their insurers will pay out if there is harm to the patient. But that contractual relationship doesn't exist everywhere. It exists on an ad hoc basis based on whoever's made this sort of contractual arrangement. This doesn't exist in all countries. So there's a big gap there. So then there is a question of, well, what about the patient wanting to seek redress against the doctor located in a different country? And that gets really complicated because the patient, your average patient is not likely to be able to hire a lawyer to bring a case against a doctor in a different country. It's an expensive process. Now, as a matter of law, the international law on this, we've looked at some principles, and I'm not going to confuse you with the details of these different principles. They're called simulation and territorial jurisdiction and passive personality. But in short, these principles are controversial, even in international law, and they may not give an avenue for an individual to bring a claim against somebody else in another country when they are harmed. They're not a good mechanism. So we're missing that effective mechanism to be able to do this. Okay. So what is a good approach to dealing with this then? Or a helpful approach? And there's been different ideas floated around. One that I particularly liked were recommendations in New Zealand by the Medical Council of New Zealand. So in the Medical Council of New Zealand, they said that where doctors are located overseas, they are not required to register where they are providing an opinion in relation to the patient under the care or responsibility of a New Zealand registered doctor. So let's say you have a patient in New Zealand, they're going to see their doctor in New Zealand, that doctor then seeks the opinion of a doctor in another country, let's say from the United States. Well, that is acceptable according to the New Zealand Medical Council because the New Zealand doctor is ultimately responsible for the care of that patient. And in any case, the doctor in America is only just providing an opinion. The challenge, though, becomes what happens if they're providing ongoing care and opinions on a long-term basis? So what should you do then? And so the New Zealand Medical Council suggests in these circumstances there should be a contract. So here we might use an area of law called contract law to protect the patient, perhaps. So there would be a formal contract written between the doctor in New Zealand and doctor in the other country, and that contract sets out the protections or who's responsible when things go wrong. So ultimately, the responsibility is with the doctor in their country. And I actually think this path probably makes most sense if you want to conduct telemedicine. So because the other areas of law are not going to protect a patient very well at all, perhaps we just need a contract between there has to be a local doctor that ultimately takes responsible via a contract with the external doctor. As a matter of practice, though, that might not always be feasible, so there will be gaps in this. Okay. So another issue, and that's just to give you a flavor of it. I'm happy to discuss it more in questions, but I must go on to the next issue. And that is, as a matter of law, I think it's also important that there is a consideration by doctors of whether telemedicine is actually appropriate for the care of the patient in those circumstances. An assessment should be done to determine whether you should actually use telemedicine. So, and that's because in some circumstances it might not be helpful at all. And so, again, this has been alluded to in Singapore and New Zealand. In Singapore, in the guidelines there, it states that physicians must ensure they have sufficient information and training to be able to manage patients through telemedicine. They're also required to communicate any limitations of telemedicine that may affect the quality of care to patients. New Zealand, again, doing well here, have also thought about this. They state that doctors should be aware of the limits of telemedicine, and they shouldn't attempt to provide a service which puts patient safety at risk. And doctors must also be aware of the risks of using telemedicine. If a physical examination will be particularly important, then the doctor shouldn't proceed to meet with the patient through telemedicine until they've had a physical examination. So some jurisdictions have specific rules in this area when you're doing this assessment. So this is something to consider. Can we bring in these ideas from different jurisdictions, these best practices, to make these determinations? So here we also can, if we take it another step further with the legal standards, I know, for example, in the laws, and I guess I don't know if the law's passed yet, but it has. Okay, but I see it's stated in section 21 here of the rules of medical diagnosis and treatments by telecommunications that informed consent should be obtained from the patient when using telemedicine. But the rules here don't really say much more about that. What is informed consent? And what do other countries give with their recommendations when it comes to informed consent? So, of course, a patient should be given accurate, adequate, and appropriate information to make an informed decision about their care. We have this process, of course, where you meet with the patient, you're supposed to discuss the case at hand, you explain the reasons for your decision, they're supposed to communicate back and forth with you, and there is certainly, this process can become a bit more complicated when you're using technology. Technology may aid it, but it may also be a barrier to it. So here, for example, the US, the Department of Health and Human Resources, sets out some guidelines in this area which might be considered here to add as, or to include as guidelines. So they state that when you meet with a patient, explain what they can expect from the telehealth visit and what their rights are. Check in with the patient about their responsibilities during online counseling or other telebehavioral health visits. So this might mean taking specific steps like wearing headphones, finding a place alone during the visit to ensure their privacy, and so on. If there's anyone observing the visit, tell the patient, get their consent at the start, instruct patients to complete required forms ahead of time and bring them. So there are guidelines out there, some reasonable, practical, useful guidelines that are being published elsewhere that we might consider incorporating here, because there's more flesh to the bones needs to be added to the rules here. And there are definitely these best practices elsewhere that we can look to. So, and this is the same in other countries. So in Australia too, there are guidelines that require that patients receive accurate and sufficient information to make informed decisions for their care. The same in Canada. There are guidelines which emphasize the importance of informed consent, and they set out how that process should be conducted. So there's plenty of examples out there which are incorporated into guidance which could be used here. This is just another point here, is educating patients. So if it's to be used, one thing that comes up consistently in guidelines is the importance of actually just having a session to explain to patients what telehealth involves and what their expectations should be from it, just to set the relationship and the expectations from the outset. Okay, so the next, and I suppose this is one of the key points here, is what about liability then when harm occurs? So I know I talked about jurisdictional issues and the challenge of how do you actually bring a case against someone in another country, but there's the other issue underlying that, which is what is the law that you apply when a patient is harmed? What are the standards that we should consider in this area? Because a doctor must exercise due care when they're monitoring patients or meeting with them. And some have argued that a separate standard of care should be created for the telehealth context. I'm not sure if that's necessary, but because in any case, we have the standard of care that we can apply, and I'm not sure if it's necessary to actually change the standard of care. And this is what most countries agree with too. So in Denmark, for example, the standard of care required in telemedicine is equivalent to that of face-to-face consultations. The same in France. So in France, it's required that the quality of care in telemedicine is equivalent to that of face-to-face consultations. So the key thing here in the rules that we find in most countries, same in Portugal, same in Singapore, we can look at different jurisdictions, is this idea of equivalence. So when the patient is meeting with the doctor virtually, it must be an equivalent level of care as it would be face-to-face. So in the guidelines, perhaps there should be some recommendations about what equivalence means, some guidance to doctors, some assessment, a checklist before meeting with the patient. Would this be an equivalent to meeting with them in person? Some form of assessment for that. And that should satisfy, at least, as a matter of standard of care, what the rules are requiring. But things get a little bit more complicated beyond that too. So there's third-party service providers. So hospitals can enlist third-party service providers in telemedicine or telehealth who may attend to individuals in virtual spaces and may be part of the care team, because it's not always just the doctor and the patient. So, these are usually independent contractors sometimes who are involved, or third-party companies. And the patients may not always be aware that these people are not employees of the hospital or the clinic that's providing the care. So communication and transparency here is key, and it's really important that hospitals or clinics have a contract with the third-party service providers that outline the responsibilities, standard of care, and liability when things go wrong. I'll conclude in just 1 minute. There is also the role of caregivers too, with similar considerations about where responsibility lies. And finally is product liability. If these devices or technology fails, is the developer or the company who's providing the service liable? And at the moment, the answer is no. Well, it's unlikely. The law is not really caught up from a healthcare law perspective to deal with this yet. It's most likely to be the hospital and the doctor that will be found liable, but I can talk about that later. Okay. So final point then is also data privacy, which is a big issue. So the issues of cybersecurity, compliance with data protection rules, because data is transmitted from multiple servers in multiple countries. And so data localization rules become very important here. What these are basically, if you are, let's say you're an entity in Taiwan and you have patient data, I'm not sure what the data protection rules are here, but generally data protection rules will stipulate whether you can send that data across borders to another country, which is important in telehealth because it could be going cross-border, the information. What some countries have are very strict rules, so they don't permit the transfer of medical data across borders. Other countries are more open, they do permit it. And then there is a third group of countries which permit the transfer of that data where it's being transferred to a country with an equivalent data protection regime. So for example, Saudi Arabia, they have a data protection law which is similar to the EU's GDPR. So for their law, it's acceptable to send health data to the EU because they have an equivalent regime of protection for patients. But those rules vary, and so again, coming into the guidelines then, there has to be something in the guidance also about data protection and the rules that are permitted within the jurisdiction that you're located, and setting out which countries have equivalent regimes or not. Okay, so I'll stop there because I heard the timer going off. Thank you so much for listening, and feel free to connect on LinkedIn if you have any questions. I'm also on X, so I'm happy to answer any questions you have after this event too. So thank you for listening.
感谢 Dr. Solaiman 带来的精彩演讲，请座长代为颁发感谢状。